So OB2 will be scored at 10 points. I mean, in PRV2, I'm sorry. Any other challenge to the prior record variables?
PRV 7, Your Honor, is incorrect, scored as 10, it should be 0.
And I would agree with that, Your Honor. That's the felony firearm.
I would agree. Scored at 0, so it remains the same
It does, Your
at 15. Adding 10 for PRV2 and diminishing 10 for
Correct.
PRV7. All right?
Honor.
All right, let's look at the offense variable. OB1 is scored at 25 points.
The people agree with that, Your Honor.
I'm not making an objection, Your Honor.
All right, it is accurately scored, I believe. OB2 is scored at 5 points, which I think is also
It is
consistent and accurate.
OB3, Your Honor, the people request 100 points.
Do you need a book?
No, Your Honor.
Are you sure?
I will let you know when I do one.
Oh, okay.
I appreciate it.
Because I have an extra one.
I appreciate it.
Okay. OB3, Mr. Howarth indicates 100 points for if a victim was killed, and that is, you get 100 points if it is a non-homicide.
I understand that, Your Honor. My problem with that, and I expressed it, I'm not as well as I would have liked to in the sentence memorandum, which I prepared for the court, is that it's my understanding that after Apprendi, the decision, and the A'naiya, if I'm pronouncing it correct, this more recent decision of the United States Supreme Court, that if we treat a separate matter as an element, then the guilt has to be found by a jury. Sometimes, or most times, it's simply something that hasn't been submitted to a jury. In this case, the homicide was submitted to the jury, and the jury found him not guilty. And I feel it's a violation of the Apprendi decision to then score 100 points.
All right. I'll note the objection. I am going to score the 100 points.
Your Honor, and for the record, just I would cite again Lockridge and People versus Laidler, 491 Mish at 339 for requesting those points.
Okay. OB4 is scored at 0. Agreed?
I agree.
Yes, Your Honor.
OB5 is scored at 0.
Your Honor, I'm going to request 15 points here for the victim's family, the victim for Miss A'naiya Montgomery's mother. She's not here in court today. I made an effort for her to be here. She's just too distraught to be in court. I think the court will recall when she testified during the trial, her demeanor and how she broke down when she was testifying and talking about her little girl. I think it's appropriate that a 3-year-old was killed as a result of this home invasion, that those points be scored 15 points for the psychological injury. It doesn't require treatment, but I think the court can see, based on you were the trial judge and you observed Miss Andrea Scott on the stand, and we had to take a break. So I would ask that the court score 15 points for that.
Mr. Howard?
I object to that, Your Honor. I think there's absolutely no objective proof that the mother of this child suffered any distress other than her demeanor and in testimony. I think it's worth noting that the mother did not appear for the rest of the trial, nor was she here for the verdict, nor was she apparently interviewed, nor has she apparently indicated in any way that she has facts that would allow the scoring of those points.
The requirements in OV5 indicate that there must be serious psychological injury requiring professional treatment. It doesn't require that someone actually have to be in treatment at the time. But I would agree with Mr. Howarth that in this particular case, there really is no objective evidence before me to support that contention about the serious psychological injury. And grant, I mean, the fact that there's the loss of a child, I mean, certainly that is horrible. But there has been no input, no information, nothing provided to the court, no response whatsoever from the deceased's mother. So I'm going to score that at 0. OVs 6, 7, and 8 are scored at 0.
People agree, Your Honor.
Defense agrees, Your Honor.
OV 9 is scored at 10.
That's accurately scored, Your Honor.
2 to 9 victims.
Certainly cannot object to that.
OV 10 is scored at 0. OV 11 is scored at 0, as doesn't apply. OV 12 is scored at 25 points. I think that's inaccurate.
I agree.
Your Honor, I would ask the court to score that at 25 points. Based on the instructions, this defendant was charged, in addition to the home invasion, with 2 counts of AWEM. He was also charged with the homicide, for which he was acquitted. This court can make a finding by a preponderance, which is what is required, that this defendant, in fact, did participate in those other crimes, and that he is, in fact, responsible for those other crimes. So OV 12 is for crimes that this defendant committed within the same 24-hour span for which he was not convicted. And I would ask the court to keep those 25 points.
I'll let you be heard, Mr. Howard, but I am inclined to score it at 0 because I do believe that OV 12, I think, is more appropriate under circumstances where someone pleads guilty and they may plead to like 1 count and 3 or 4 other charges may be dismissed. In this particular case, the matter went to a jury. The jury made a finding, and I am going to, for purposes of sentencing guidelines, honor that particular jury verdict, and I am going to score it at 0. OV 13 is scored at 0.
Yes, Your Honor.
Agreed.
OV 14 is scored at 0. I scored it differently. I scored it at 10 points. The OV 14 is the offender role. Offender was a leader in a multiple offender situation. The instructions indicate if 3 or more offenders were involved, more than 1 offender may be determined to have been a leader.
I would disagree, Your Honor. I think that the leaders in this were, number 1, Jose Jackson, the man whose tennis shoes were stolen, the man who put this entire plot into action. The second leader would certainly have been Mr. Street, who is the person that instructed Mr. Burks to accompany them to the site, and certainly Mr. Kendall, who is the one who went armed and did the actual shooting while Mr. Burks sat in the car doing apparently nothing. We sort of run out of other actors who did more than he did. Even Mr. Diallo Davis, who was there, approached the house and fired a gun at it. If we take all of the people that left the house on Forrer Street and went to the house on Riverview, I would say the person who did the least would have been Mr. Burks.
Well, I disagree in this particular matter. When Mr. Jackson came back with his tall tale, about how he ended up in the circumstance that caused him to be without his Air Jordan tennis shoes. One of his brothers just blew it off initially, thinking that Mr. Jackson was lying, and that there wasn't anything to it, and there wasn't any purpose to getting involved in that. But it was Mr. Burks who was the one who got things really going. He's the one who ended up getting a hold of Mr. Kendall, the one who everybody acknowledged was the one who was the hothead, the one who carried the gun, the one who was likely to do something. And Mr. Burks was the one who ended up riding over in the same vehicle with the killer, Mr. Kendall. Now, I understand that Mr. Burks' position was that he did nothing. I reject totally the idea that Mr. Burks was brought along just as a spectator to watch what was going on. He was there certainly to be the getaway car driver from this particular episode. I do find that Mr. Burks was a very active leader, and in my view was the main reason why this deadly action was initiated. The objections noted, OV 14 will be scored at 10 points. OVs 16 through 20 appear to be inapplicable and are scored correctly, I believe, at 0. Agreed?
Yes, Your Honor.
Yes, Your Honor.
Okay. Which gives us a total of 150 points,
That's correct, Your Honor.
noting the defense objection. And with regards to the scoring of the guidelines,
Your Honor, I have them scored at 57 to 142.
all right, I always allow the defense to have the last word at sentencing. Let me hear from the people.
Your Honor, in this case, the defendant, as a third habitual, faces a maximum term of 40 years in the Department of Corrections. If the court examines the guidelines for 57 to 142, even though they're advisory only, certainly the law says that the court should examine the guidelines. And looking at the guidelines, the defendant has twice as many points as the 75 required by the guidelines for that range, which the top end would be 142 from 13 some years. But nonetheless, the maximum sentence that this court can impose, which the people believe is a reasonable sentence under Lockridge, is 26 to 40. The people would ask the court to impose that sentence based on the defendant's role in this homicide. As the court indicated, he was the leader. He in fact called Paul Kendall, but for him calling Paul Kendall, probably none of this would have happened. Once Paul Kendall became involved, and the defendant knew about Paul Kendall's history, he knew about his violent conduct, he called him over to that situation, which resulted in the death of not only A'naiya, which is scored, but we also have 2 AWIM victims inside that house. So we had other multiple victims inside that house. The people would request 26 to 40 years.
Mr. Howard.
Thank you, Your Honor. Well, Your Honor, obviously the prosecution and I see this case very differently, and I'm respectful, of course, of the court's feelings, which have been partially made known through the discussion on the guidelines. I just don't see the case that way. First of all, when you look at the past criminal history of Mr. Burks, it is minor, to say the least, as far as the fact that he's been convicted of 2 felonies. He has 1 incident in Oakland County with checks. It's not like a history of passing bad checks. In 1 instance, he has violated criminal laws of the state of Michigan before the instance in April of this year. That is hardly a serious criminal history for a 31-year-old Detroit male. Furthermore, Your Honor, Mr. Burks has a lot in his personal background that should call out for some sympathy from the court. He is not a person who is in good physical health. He suffers from sickle cell anemia. He probably has a shortened life expectancy than would a normal person of his age. He has 3 children. One of his 3 children is similarly afflicted with that disease. And Mr. Burks, as far as I have understood it, has attempted to provide moral support and financial when he can to his children. When we looked at the facts of the case, we all sat here and heard it together, as did this jury. The jury was very sympathetic to the position of Mr. Burks. The jury did not find him to have legal criminal responsibility either for the death of the young child, which was tragic, nor of the shootings of the other 2 innocent bystanders in the house. So much emphasis is put on the telephone call that Mr. Burks made to Mr. Kendall, and I understand that. But there was absolutely no testimony that I heard in this court as to what it was that Mr. Burks said to Mr. Kendall, other than the fact that his brother, Jose Jackson, had been shot and his tennis shoes had been robbed. Those facts, of course, were not even true. That was a fact that was unknown to Mr. Burks. Mr. Burks was relying on what was said to Mr. Street, and Mr. Street relaying that to Mr. Burks. It does seem that there is one non-involved person who goes to the scene, and that is Mr. Burks. If he wanted to take part in this, I don't think it would have been very difficult to find a gun in that house on Forest Street or to borrow one from the other participants. I don't think it would be very difficult for Mr. Burks to have gotten out of the car and approached the house. I don't think it would have been difficult for Mr. Burks to fire on that house. He did none of those things as far as the testimony was concerned. He went, he was an observer, he shouldn't have gone, there's no question, but that he shouldn't have gone. He did, and he's going to pay for it, and he's going to pay dearly. But I ask that we not put more on his plate than he deserves to have. And I think that under the circumstances of this case, a minimal sentence at the low end of the guidelines should be imposed, especially inasmuch as the jury chose to find him guilty of felony firearm, and he's going to do 24 months of incarceration. Mr. Burks' incarceration to date has not been easy. Mr. Burks had reported to me through his family last week that he was attacked in the Wayne County Jail and was somewhat seriously injured in that the attack was most unfriendly. I think he's not going to have a smooth time in the criminal justice system. I ask under all the circumstances of this case that a sentence be imposed on the low end of the guidelines, and I believe that that will reflect the role of this offender in the crime that was committed.
Thank you, Mr. Howard. Mr. Burks, this is the date and time scheduled for sentencing in this matter. Is there anything that you would like to say?
I would just like to say that I'm sorry for what happened to the little girl. I have very deep emotions for that because I have a little girl myself, and I never meant for nobody to be hurt. And I just want to say I'm sorry for what happened. And I just wish that you would help me to get the least time I can get so I can make it home to be my daughter. My daughter have had brain surgery and had a stroke since I've been in here. And I just want to make it home to my daughter before I either pass away or she pass away.
Well, Mr. Burks, if you have a small child, then you, of all people, should have known what possible harm and what possible heartache could come from gunfire being utilized in a small residential place where there was a 3-year-old child. In this particular case, you mobilized an angry, volatile young person that you knew to be angry and volatile and who had a penchant for using guns to come over and rally with you because of someone's missing tennis shoes. A 3-year-old child has no future. There's a heartache for that family because it was your idea. You were the one who instigated the phone call and all of the action that led to a 3-year-old child being murdered on Easter Sunday. I know that your position has been that you didn't do anything, that you were just there watching. Well, the jury didn't believe that, and I don't believe that. Nobody brings spectators to a murder. You were involved. You were there in the car with the shooter driving there, and you were there with the shooter driving away, and you were prepared to be the wheelman to drive away. And but for your active involvement, that 3-year-old child would be alive today. You bear enormous responsibility. I am aware that under People versus Lockridge, that the sentencing guidelines are advisory, and I do take into account that they are advisory. Recognizing the guidelines as they are, 57 to 142 months, I do think that the guidelines do not adequately reflect the serious harm that was done in this particular matter. On the charge of felony firearm, it's the sentence of the court that should be committed to the Michigan Department of Corrections for a period of 2 years. There is credit for 143 days spent in custody. And for the reasons I just articulated about Mr. Burks' role in this particular matter, as a third offender habitual on the charge of home invasion in the first degree, it's the sentence of the court that should be committed to the Michigan Department of Corrections for a period of not less than 18 years, period not greater than 40 years. That's consecutive to the 2 years on the felony firearm. You have the right to file a claim of appeal with the Michigan Court of Appeals. If you choose to do so, you must do so within 42 days. If you can't afford to hire an attorney, the court will appoint an attorney, furnish the attorney with portions of the transcript and record that may be needed. That also has to be done within 42 days.
Still got officers.